I was standing in my driveway watching a construction crew rip up my front yard when I realized my HOA had just made the biggest mistake of their lives. The heavy machinery rumbled across what used to be my pristine lawn, tearing through grass and soil like it was nothing. I had come home early from my job at the insurance firm in downtown Phoenix, Arizona, because my neighbor had called me in a panic. "Carter, you need to get home right now. There are trucks everywhere and they're destroying your property." I had driven 70 miles per hour the whole way, my knuckles white on the steering wheel of my Ford F-150. When I pulled onto Sagaro Vista Drive, my street in the planned community of Desert Highlands, I couldn't believe what I was seeing. Orange cones lined the road. A backhoe sat in my driveway. And right there, right where my grandfather's old well had been for over 60 years, was a massive pile of concrete and asphalt. "What the hell is going on here?" I shouted as I jumped out of my truck. A construction worker in a yellow vest looked up from his clipboard. "HOA project, sir. We're just following orders." "Orders? What orders? Nobody told me anything about this." The worker shrugged. "You'll have to take it up with the HOA. We're just the contractors. We were told to pave over this old well structure and connect your property to city water. Something about safety violations and community standards." My blood pressure spiked so fast I could hear my pulse pounding in my ears. "That well has been on this property since 1963. My grandfather dug it himself. You can't just pave over it." "Already did, sir. See." He pointed to the fresh concrete that now covered where my well access had been. The distinctive stone cap my grandfather had laid was completely buried under industrial gray cement. I pulled out my phone and immediately dialed the HOA office. A chirpy voice answered on the third ring. "Desert Highlands Homeowner Association. This is Sharon speaking. How may I help you?" "This is Carter Newberry on Sagaro Vista Drive. There's a construction crew at my house destroying my property. I need to speak to whoever authorized this right now." "Oh, Mr. Newberry. Yes, the board sent you several notices about the mandatory water system upgrade. Since you didn't respond, we proceeded with the work as outlined in the community guidelines. I never received any notices, not a single one." "Well, they were sent to your address on file. The board voted 3 months ago to require all properties to connect to city water and decommission any private wells. It's for the safety of the community. You can't force me to do that. That well is my property." Sharon's voice took on a practiced, condescending tone that made my teeth grind. "Actually, Mr. Newberry, according to Section 12.4 of the Desert Highlands CC and Articles, the board has the authority to mandate infrastructure improvements for the health and safety of the community. The decision is final. You'll receive a bill for your portion of the city water connection within 30 days. A bill? You're charging me for work I never authorized. It's all in the guidelines you agreed to when you purchased your home. Have a wonderful day." She hung up before I could respond. I stood there staring at my phone, absolutely stunned. I had bought this house from my grandfather's estate 2 years ago when he passed. He had built it himself back in the early 60s, long before Desert Highlands existed as a planned community. The developers had built around his property, and eventually, the HOA had absorbed it into their jurisdiction. But that well was grandfathered in. It had to be. The construction crew was already packing up. I watched helplessly as they loaded their equipment onto trailers. The backhoe rumbled to life and drove up onto a flatbed truck. Within 30 minutes, they were gone, leaving behind a torn-up yard, fresh concrete where my well had been, and a new water meter installed on the side of my house. I walked over to the concrete pad. It was still slightly wet, the surface smooth and featureless. Somewhere underneath was the stone cap my grandfather had carved with his initials and the date, JN, 1963. I felt a surge of anger so intense I had to walk away before I did something stupid. My neighbor, Frank, came over from across the street. He was a retired veteran in his 70s with a no-nonsense attitude I usually appreciated. "That's rough, Carter. They did the same thing to the Hendersons 2 months ago, paved right over their decorative fountain without permission." "How is this legal?" The HOA president, Brenda Hutchins, she's on a power trip. "Been pushing all these improvements through without proper votes. Most of the neighborhood is scared to fight back because she threatens fines and liens." "Brenda Hutchins," I repeated, memorizing the name. "I need to talk to her." "Good luck. She doesn't take kindly to being questioned. Last guy who challenged her got slapped with 17 different violations in 1 week. Everything from his grass being a 1/4 inch too long to his mailbox being the wrong shade of beige." I thanked Frank and went inside my house. I needed to think. I needed to plan. But most importantly, I needed to figure out exactly what legal ground I was standing on. My house was a classic mid-century ranch style, single story with big windows and clean lines. My grandfather had built it to last, with solid construction that had weathered 60-plus years of Arizona heat. I went to my home office and pulled out the box of documents I had inherited with the property. Deed, title, plot maps, and buried at the bottom, a yellowed piece of paper I had only glanced at before, water rights certificate. I unfolded it carefully. The paper was brittle with age, but the ink was still clearly legible. It was dated March 15, 1963, and signed by the Maricopa County Water Authority. It granted my grandfather, James Newberry, exclusive rights to all groundwater beneath his 5-acre property, with no expiration date. The document specifically stated that these rights were perpetual, transferable, and not subject to municipal override without just compensation. I read it 3 times to make sure I understood what I was looking at. Then I started laughing. It wasn't a happy laugh. It was the kind of laugh that comes when you realize someone has made a catastrophic mistake, and they don't even know it yet. The HOA hadn't just paved over my well. They had paved over my legally protected water source. And they had forced me onto city water when I owned the rights to the groundwater beneath not just my property, but potentially the entire neighborhood. Desert highlands had been built on what used to be open desert. My grandfather's 5 acres had been subdivided over the years, but those water rights had never been transferred. They had come to me with the property. I grabbed my phone and started searching for water rights attorneys in Phoenix. I needed someone who specialized in this exact kind of case. After an hour of calls, I found myself on the phone with a lawyer named Richard Martinez, who had handled several high-profile water rights disputes in Arizona. "Mr. Newberry, if what you're telling me is accurate, the HOA has committed a serious violation. Water rights in Arizona are extremely valuable, and interfering with someone's legal access to their water source can result in substantial damages," Richard said. "Can they force me to use city water?" "Not if you have a valid water rights certificate. Arizona is a prior appropriation state when it comes to water. First in time, first in right. If your grandfather secured those rights in 1963, they supersede any HOA rules or city ordinances. The fact that they physically prevented you from accessing your water source by paving over your well is actually a form of trespass and possibly theft of resources. What do I do? First, I need to see all your documents. Can you come to my office tomorrow morning? Second, stop using the city water if possible. We want to establish that you're still actively asserting your water rights. And third, Don't sign anything the HOA sends you, especially any bills for the water connection. We scheduled an appointment for 8 o'clock the next morning. I spent the rest of the evening going through every document I had, making copies of everything related to the water rights and the property history. The next day, I sat in Richard's office in downtown Phoenix. His office was on the 15th floor of a glass building with a view of the desert mountains. He reviewed my documents carefully, occasionally making notes on a legal pad. "This is excellent," he finally said. "Your grandfather was smart." He secured these water rights before the city expanded into this area. And look here, the certificate includes subsurface water rights for the entire original 5-acre parcel. Even though the land has been subdivided, the water rights weren't. You own the groundwater beneath approximately 40 homes in your development. I blinked. 40 homes, according to this plot map and the subdivision records, yes. Your grandfather's original parcel was divided into smaller lots in 1985, but the water rights certificate was never amended. It stayed with the original property, which is now your house. Technically, every home in your section of desert highlands is sitting on top of water that you have legal rights to. So the HOA messed up big time, catastrophically. Not only did they interfere with your water access, but by forcing you onto city water, they've damaged you financially. You'll now have to pay for water that you legally have the right to access for free. We can sue for the cost of restoring your well, compensation for lost access, ongoing damages for water bills, and possibly punitive damages for the HOA's actions. What's our first step? Richard smiled. It wasn't a friendly smile. It was the smile of a lawyer who had just found a winning case. We send them a cease and desist letter, inform them of your water rights, and demand immediate restoration of your well access. We give them 10 days to respond. If they refuse or ignore us, we file suit in Maricopa County Superior Court. Let's do it. The letter went out that afternoon via certified mail. Richard drafted it to be crystal clear. I owned the water rights. The HOA had violated those rights, and they had 10 days to restore my well access and remove the concrete covering it, or face legal action. I went home feeling better than I had in days. But when I pulled into my street, I saw a bright orange violation notice stapled to my front door. I ripped it down and read it. According to HOA President Brenda Hutchins, I was in violation of community standards for unmaintained lawn, the lawn the construction crew had destroyed, unpermitted structures, what structures, and failure to maintain property aesthetics. Total fines, $800 due in 14 days. This was retaliation, pure and simple. Frank had warned me this would happen. I took a photo of the notice and texted it to Richard. His response came back in seconds. "Don't pay it. This supports our case for harassment." 2 days later, I got another violation notice. This time for my mailbox being non-standard, even though it had been the same mailbox for 60 years. Another $500 fine. Then another notice about my house color being not in compliance, even though I hadn't painted it, and it was the original color from when it was built. I was up to $2,000 in fines within a week. Each notice was signed by Brenda Hutchins in aggressive, looping handwriting. I saved every single one and sent copies to Richard. On day 8, I got my first look at Brenda Hutchins in person. I was checking my mail when a white Mercedes SUV pulled up in front of my house. A woman in her late 40s climbed out, wearing expensive athletic wear and designer sunglasses. Her blonde hair was pulled back in a tight ponytail, and her lips were pressed into a thin line of disapproval. "Carter Newberry," she called out. "That's me. I'm Brenda Hutchins, president of the Desert Highlands HOA." We need to talk about your mounting violations and your refusal to pay for the water system upgrade. I never authorized that upgrade. You destroyed my property without permission. She walked up my driveway like she owned it, her heels clicking on the concrete. The board has the authority to make improvements for the community's benefit. Your old well was a safety hazard. It wasn't properly maintained, and it posed a risk of contamination to the water table. That's complete nonsense. The well was perfectly maintained and had been inspected regularly. Do you have inspection records? I did, actually. They were in the box with all my other documents. Yes. That seemed to surprise her, but she recovered quickly. Regardless, the decision has been made. You're now on city water like everyone else. The bill for the connection is $3,500. It's due in 3 weeks. I'm not paying it. Her face flushed red. Excuse me. You heard me. I'm not paying for work I never authorized and didn't want. You had no right to touch my property. Mr. Newberry, I don't think you understand how an HOA works. When you bought this property, you agreed to abide by our rules and regulations. The board has the authority to enforce those rules, including mandatory upgrades. If you don't pay, we'll place a lien on your property. Go ahead and try. You'll be hearing from my lawyer. Brenda's eyes narrowed behind her sunglasses. So it's going to be like that, is it? You want to be difficult? Fine. I've dealt with stubborn homeowners before. They always lose. She pulled out her phone and started typing. I'm documenting 12 additional violations I can see just from standing in your driveway. Cracked concrete, oil stains, improper landscaping, unauthorized gravel placement, and several others. That's another $3,000 in fines. You're making this up as you go. I'm enforcing community standards. If you have a problem with that, take it up with the board at the next meeting. 3rd Thursday of the month, 7 p.m. at the community center. But I'll warn you now, the board always sides with me. I've been president for 5 years and I have yet to lose a vote. She turned and walked back to her Mercedes, climbing in and driving away without another word. I stood there holding my mail, absolutely furious. This woman was drunk on power, and she clearly thought she was untouchable. I called Richard immediately. We need to accelerate this. The HOA president just showed up at my house threatening me with more fines. The 10 days aren't up yet. Let's see if they respond to the cease and desist first, but start documenting everything. Every interaction, every violation notice, every threat. It's all evidence. The 10 days came and went. The HOA never responded to Richard's letter. On day 11, we filed a lawsuit in Maricopa County Superior Court. The complaint was 30 pages long and detailed every violation of my property rights, every illegal fine, and every act of harassment. We sued for restoration of the well, compensation for damages, repayment of any water bills I had incurred, and punitive damages for the HOA's willful misconduct. The HOA was served with the lawsuit 3 days later. I wasn't there when the process server showed up at their office, but I heard from Frank that Brenda had thrown an absolute fit, screaming about ungrateful homeowners and frivolous lawsuits. What came next was predictable but still infuriating. Within 24 hours of being served, I received a notice that my property had been placed under special review status by the HOA board. This meant they could conduct weekly inspections and issue violations for any infractions they found. It also meant I was now subject to additional fees for the increased administrative burden of monitoring my property. I photographed the notice and sent it to Richard. His response: "Perfect. This is textbook retaliation. They're making our case for us." The weekly inspection started immediately. Every Monday morning at 8 a.m., a different board member would show up with a clipboard and walk around my property, taking notes and photos. They found violations in things I didn't even know could be violations. My doormat was too close to the door. My garden hose wasn't coiled properly. My trash cans were 6 inches too far from the house on a non-trash day. Each inspection resulted in 5 to 10 new violations and hundreds of dollars in additional fines. After 4 weeks, I was up to over $15,000 in alleged violations. The HOA sent me an official notice that if I didn't pay within 30 days, they would begin lien proceedings on my house. Richard filed an emergency motion for a temporary restraining order to stop the inspections and halt any lien proceedings. The hearing was scheduled for a Friday morning in front of Judge Patricia Morrison. I took the day off work and met Richard at the courthouse. It was a modern building in downtown Phoenix, all glass and steel and security checkpoints. We went through screening and made our way to courtroom 4B on the 3rd floor. Brenda was already there with the HOA's attorney, a slick-looking guy in an expensive suit named Gregory Allen. They sat on the opposite side of the courtroom, whispering to each other and occasionally glancing in my direction. Judge Morrison took the bench at exactly 10 a.m. She was a woman in her 60s with steel gray hair and reading glasses perched on her nose. She looked over the paperwork in front of her, then looked up at both legal teams. "This is a hearing on the plaintiff's motion for a temporary restraining order. Mr. Martinez, you're representing the plaintiff, Carter Newberry." Richard stood. "Yes, Your Honor." "And Mr. Allen, you're here for the Desert Highlands Homeowner Association." "That's correct, Your Honor." "All right, Mr. Martinez, make your argument." Richard laid out the case methodically. He presented the water rights certificate, explained how the HOA had paved over my well without permission, and detailed the pattern of retaliatory fines and harassment that had followed my lawsuit. He introduced copies of every violation notice I had received, showing how they had escalated dramatically after I filed suit. "Your Honor, the HOA is engaging in clear retaliation against my client for exercising his legal rights. They've buried him in frivolous violations and are threatening to lien his property for manufactured infractions. This is economic harassment designed to force him to drop his lawsuit. We're asking the court to issue a temporary restraining order preventing any further inspections, fines, or lien proceedings until this case can be resolved on its merits." Judge Morrison turned to Gregory Allen. "Mr. Allen, your response." The HOA's attorney stood smoothly. "Your Honor, the HOA is simply enforcing its community standards as it has the right and obligation to do. Mr. Newberry agreed to these standards when he purchased his property. The timing of the increased scrutiny is coincidental, not retaliatory. The board has documented legitimate violations of the community guidelines." "Coincidental," Richard interrupted. "Your Honor, my client went 2 years without a single violation notice. Then, within days of asserting his water rights, he suddenly has $15,000 in fines. That's not coincidence, that's retaliation." Judge Morrison held up a hand. "Mr. Martinez, you'll have a chance to respond." Mr. Allen, continue. "Your Honor, the board takes its responsibilities seriously. When a homeowner becomes litigious and hostile, it's natural that the board would want to ensure that property is in full compliance. This is about protecting property values for the entire community, not targeting any individual." "What about the water rights certificate?" Judge Morrison asked. "Have you reviewed that document?" Gregory Allen shifted slightly. "We're aware of a document Mr. Newberry has produced. However, we believe it's either fraudulent or has been superseded by subsequent water management regulations. The city has jurisdiction over water resources in this area now." That's absolutely false, Richard said. Arizona water law is clear. Prior appropriation rights are protected. The certificate is recorded with the county and has never been invalidated. Judge Morrison flipped through the documents in front of her. I'm looking at the water rights certificate now. It appears to be properly executed and recorded. Mr. Allen, do you have any evidence that this document has been superseded or invalidated? Not at this time, Your Honor, but we intend to research that issue further. In other words, no. Judge Morrison made a note on her pad. What about the destruction of the well? Who authorized that work? Gregory Allen glanced at Brenda. The HOA board authorized it as part of a community-wide infrastructure upgrade. It was done for safety and compliance reasons. Was Mr. Newberry given notice and an opportunity to object? Notices were sent according to HOA procedures. That's not what I asked. Did Mr. Newberry receive actual notice? Another glance at Brenda. We sent notices to the address on file. Mr. Newberry, did you receive any notices about this work before it happened? Judge Morrison asked me directly. I stood. No, Your Honor. The first I knew about it was when I came home and found construction crews in my yard. Judge Morrison frowned. That's troubling. Mr. Allen, even if the HOA had the authority to mandate this upgrade, which I'm not conceding they did, they still need to provide actual notice to affected homeowners. You can't just show up and start destroying someone's property. Your Honor, the notices were sent. If Mr. Newberry didn't receive them, that's not the HOA's fault. I'm going to disagree with you there. If you're going to take action that affects someone's property rights, you need to ensure they actually receive notice. Certified mail process server, something that confirms receipt. Did you do that? Silence from the HOA's table. I'll take that as a no. Judge Morrison made several more notes, then looked up. Here's what I'm going to do. I'm granting the temporary restraining order. The HOA is hereby prohibited from conducting any further inspections of Mr. Newberry's property, issuing any new violation notices, or proceeding with any lien actions until this case is resolved. The existing fines are stayed pending the outcome of litigation. Additionally, I'm ordering the HOA to allow Mr. Newberry access to conduct a professional assessment of what it would take to restore his well. Your Honor, that's highly unusual, Gregory Allen protested. So is paving over someone's water source without their permission. My order stands. We'll have a full hearing on the merits in 60 days. Both sides need to be prepared to present evidence on the validity of the water rights certificate, whether the HOA had authority to mandate the well closure, and whether the subsequent fines constitute retaliation. Any questions? Neither attorney spoke. Good. My clerk will provide you with the written order. Court is adjourned. I felt like I could breathe for the first time in weeks. As we left the courtroom, I could hear Brenda Hutchins' voice rising in anger as she berated Gregory Allen. Richard and I walked to the elevator bank and I shook his hand. Thank you. That was amazing. We got a good judge. Morrison is fair and doesn't tolerate nonsense. But this is just the first round. The real battle is going to be at the full hearing. We need to build an airtight case. What do we need? We need to get a water engineer out to your property to assess the well situation. We need to document the full extent of the HOA's harassment, and we need to research comparable cases to establish damages. This is going to be a fight, Carter. I'm ready. Over the next 2 weeks, I hired a water engineering firm to come out and examine my property. They used ground-penetrating radar to map out the well structure beneath the concrete. The engineer, a guy named Dennis who had been working in Arizona water systems for 30 years, spent 3 days taking measurements and samples. His report was detailed and damning. The well was completely intact beneath the concrete, but accessing it would require breaking up the entire pad the HOA had poured. The well itself was in perfect condition and had been properly maintained. There was no evidence of any safety hazards or contamination risks. In Dennis's professional opinion, there had been no legitimate reason to close the well, and doing so had cut off access to a high-quality water source that could produce up to 50 gallons per minute. This well could supply water for multiple homes, Dennis told me as he packed up his equipment. Your grandfather knew what he was doing when he dug it. It taps into one of the best aquifers in this part of the valley. The water quality is actually better than city water. Can it be restored? Absolutely. It'll take some work to remove all that concrete and make sure the well casing wasn't damaged when they paved over it. But yes, it's definitely salvageable. I'd estimate about $12,000 for the restoration work. I added that number to our damages calculation. Richard was building a comprehensive case. We had the water rights certificate, the well engineer's report, documentation of every violation notice and fine, and witness statements from neighbors about the HOA's pattern of harassment. But Brenda wasn't done fighting. Even though the restraining order prevented her from issuing new violations against me, she found other ways to make my life difficult. She started holding emergency board meetings to discuss the Newberry problem. Minutes from these meetings, which I obtained through a public records request, showed her describing me as a troublemaker and threat to community harmony. She also began pressuring my neighbors. Frank told me that Brenda had approached him and several other residents, asking them to sign statements saying my property was an eyesore and that I was a bad neighbor. Most people refused, but a few caved to her pressure. She was building her own case, trying to establish that I was the problem, not her. The HOA also sent out a special newsletter to all residents, warning them about frivolous litigation that was costing the community money in legal fees. The newsletter didn't mention me by name, but it was obvious who they were talking about. It painted me as a selfish homeowner who was putting his own interests above the good of the community. I showed the newsletter to Richard. He just laughed. More evidence of retaliation and defamation. Keep it. Everything they do just makes our case stronger. As the 60-day deadline for the full hearing approached, I started to feel the stress. I was sleeping poorly, distracted at work, and constantly worried about what Brenda would do next. The whole situation felt surreal. All I wanted was to protect my grandfather's legacy and maintain my property rights, and I was being treated like a criminal for it. The full hearing was scheduled for a Wednesday morning. Richard had prepared extensively, lining up expert witnesses and organizing our evidence into a clear, compelling narrative. I took the entire week off work to focus on the case. The night before the hearing, Richard and I met at his office to go over our strategy one final time. Tomorrow is going to be long, he warned me. The HOA is going to attack your character, question the validity of the water rights, and try to paint themselves as the victims. You need to stay calm no matter what they say. I'll do my best. The judge is going to want to hear from you directly. She'll ask about your grandfather, the well, what happened when the construction crew showed up. Be honest, be factual, and don't exaggerate. Just tell the truth. I went home and tried to sleep, but ended up lying awake most of the night, staring at the ceiling and rehearsing what I would say. The courtroom was packed when we arrived the next morning. Apparently, word had spread through the Desert Highlands community, and dozens of residents had shown up to watch. Some were there to support me, but many were clearly on Brenda's side. I recognized several board members sitting in the front row behind the HOA's legal team. Judge Morrison took the bench at 9 a.m. sharp. This is the case of Carter Newberry versus Desert Highlands Homeowner Association. We're here for a full hearing on Mr. Newberry's complaint regarding water rights and HOA violations. This is going to be a long day, so let's get started. Mr. Martinez, call your first witness. Richard called the water engineer Dennis first. Dennis walked the court through his findings, using diagrams and photos to show the well structure and explain why it was a valuable resource. He testified that there was no safety reason to close the well, and that doing so had destroyed access to a high-quality water source. On cross-examination, Gregory Allen tried to poke holes in Dennis's testimony. Isn't it true that private wells can be contaminated? They can be, yes, but this one wasn't. We tested the water quality and it exceeded all EPA standards. But there's always a risk, isn't there? There's a risk with any water source, including city water. In fact, this well water had lower levels of certain contaminants than the municipal supply. Allen moved on quickly. Isn't it also true that maintaining a private well is expensive and time-consuming? It requires regular maintenance, yes, but so does any water system. The cost of maintaining this well would be far less than paying for city water over time. Richard's next witness was a water rights attorney who specialized in Arizona water law. She testified about the prior appropriation doctrine and explained why the water rights certificate I held was legally valid and enforceable. She also testified that the HOA had no authority to override those rights, regardless of what their community guidelines said. In Arizona, water rights are property rights, she explained. They can't be taken away without due process and just compensation. The HOA's actions here amount to an illegal taking. Gregory Allen challenged her on cross-examination. But isn't it true that water law in Arizona has evolved since 1963? Don't cities and counties have more authority now to regulate water resources? They have authority to regulate new appropriations, but existing rights are protected. Mr. Newberry's grandfather secured these rights decades ago. They're grandfathered in. What if the well poses a danger to the community? Then the proper procedure is to get a court order to shut it down, not to just pave over it without notice. And in this case, there's no evidence of any danger. Richard then called me to the stand. I was nervous as I walked up and was sworn in, but once I started talking about my grandfather and the property, I felt more confident. Richard walked me through the history of the property, how my grandfather had built the house and dug the well, how I had inherited it, and what had happened when the HOA paved over the well without my knowledge. I described coming home to find construction crews in my yard and the shock of seeing my grandfather's well buried under concrete. How did you feel when you saw what had been done? Richard asked. Violated. Angry. That well was part of my family history. My grandfather built it with his own hands, and they just destroyed it without even telling me. What happened after you tried to object? I described my interactions with Brenda Hutchins, the mounting violation notices, the harassment, and the threats. Richard introduced each violation notice into evidence, and I explained how each one was either completely fabricated or for something that had never been a problem before. Then, it was Gregory Allen's turn to cross-examine me. He stood up with a legal pad covered in notes and approached the witness stand. Mr. Newberry, when you purchased this property, you agreed to abide by the HOA's rules and regulations, correct? I agreed to reasonable rules, yes. And those rules include provisions about property maintenance and community standards. Yes, but they don't include the right to destroy my property without notice. We'll get to that, but you acknowledge that you're bound by the HOA's rules. Within reason, yes. And when the HOA board makes a decision about community improvements, homeowners are expected to comply, correct? If the decision is legal and properly made, yes, but this wasn't. You're not an expert in HOA law, are you? No, but I know property rights when I see them. Gregory Allen changed tactics. Your grandfather dug this well in 1963. That was over 60 years ago. How often was it inspected for safety? Regularly. I have inspection records going back 20 years, but not all the way back to when it was built. My grandfather maintained it himself before that. So you don't actually know if it was properly built to code. There wasn't a code for private wells in 1963. And yes, it was properly built. The engineer's report confirmed that. But wells can deteriorate over time, can't they? Especially ones that are over 60 years old. This one didn't. It was in perfect condition. Allen asked several more questions, trying to establish that the well might have been a safety hazard and that the HOA had acted reasonably. I pushed back on each point, staying calm and factual like Richard had advised. When I was finally dismissed from the stand, I felt exhausted but relieved. Richard gave me a small nod of approval as I returned to the plaintiff's table. The HOA called their witnesses next. Gregory Allen started with a member of the HOA board, a man named Robert Chen, who was the treasurer. Robert testified that the board had voted unanimously to require all homes to connect to city water, and that the decision had been made for safety reasons. We had concerns about old private wells contaminating the aquifer, Robert said. It was in the best interest of the entire community to shut them down. How many private wells were there in the community? Richard asked on cross-examination. I believe just 2. And where was the other one? It was on a property on the north side of the development. Is that well still in operation? Robert hesitated. I'm not sure. You're not sure? Didn't you just testify that shutting down private wells was critical for community safety? Well, yes, but I don't know the status of that particular well. Let me help you out. That well is still in operation, isn't it? The board never paved over it or forced that homeowner onto city water, did they? I would have to check the records. So the board's safety concerns only applied to my client's well, not to the other one. I don't know the circumstances of the other property. Richard pressed him. Isn't it true that the other well is on a property owned by a board member, and that's why it was left alone? Gregory Allen objected. Speculation, Your Honor. Sustained, but Mr. Martinez, you're raising an interesting point. We'll need more information on this. Richard sat down, satisfied. The fact that another well in the community was still operating completely undermined the HOA's safety argument. Next, the HOA called Brenda Hutchins to the stand. She walked up confidently, wearing a business suit and her trademark tight ponytail. She was sworn in and sat down, crossing her legs and folding her hands in her lap. Gregory Allen asked her to explain the board's decision-making process and why they had determined that closing private wells was necessary. Brenda launched into a prepared speech about community standards, property values, and safety concerns. She made it sound like the board had agonized over the decision and had only acted after careful consideration. The fact is, Mr. Newberry's well was old and potentially dangerous, Brenda said. We couldn't risk contamination spreading to other properties. We did what we had to do to protect the community. And the violation notices that were issued to Mr. Newberry after he objected, Allen asked. Those were routine enforcement actions. Mr. Newberry's property was in violation of numerous community standards. The board has a duty to enforce those standards equally for all homeowners. So the timing was coincidental, absolutely. We inspect properties regularly, and Mr. Newberry's property happened to come under review at that time. Richard stood up for cross-examination. I could tell he was looking forward to this. Miss Hutchins, you testified that the board inspects properties regularly. How often? It varies depending on need. Before Mr. Newberry filed his lawsuit, when was the last time his property was inspected? Brenda shifted in her seat. I would have to check our records. Let me help you. It had never been inspected before, had it? Not once in the 2 years he owned the property. I don't recall. But suddenly, after he objected to the well closure and filed a lawsuit, his property was being inspected weekly, and he was receiving dozens of violation notices. That's quite a coincidence, isn't it? We inspect properties when issues are brought to our attention. What issues were brought to your attention regarding Mr. Newberry's property? His lawn was overgrown. Wasn't his lawn torn up by the construction crew that the HOA hired? Brenda's face flushed. I don't recall the specific circumstances. Miss Hutchins, you personally signed every one of the violation notices issued to Mr. Newberry. You were aware of every fine. Are you really telling this court that you don't remember that his lawn was destroyed by the HOA's own construction crew, and then you fined him for having a damaged lawn? Our records show that his lawn was not properly maintained. Richard picked up a stack of papers. I have photographs here taken by Mr. Newberry's neighbor the day before the construction crew arrived. His lawn was green and well maintained. Would you like to see them? Brenda didn't answer. Let me ask you about the water system upgrade. How many homeowners were given notice before work began on their properties? Notices were sent to all affected homeowners. How were they sent? By regular mail to the addresses on file. Not certified mail, not hand-delivered, just regular mail. That's correct. And if a homeowner claims they never received the notice, that's not the HOA's responsibility. Really? You think you can destroy someone's property based on a notice they may never have received, and that's acceptable? We followed our procedures. Your procedures resulted in Mr. Newberry's property being damaged without his knowledge. Don't you think you should have made more effort to ensure he was actually informed? We did what we were required to do under the HOA guidelines. Richard changed direction. Let's talk about the water rights certificate. Were you aware that Mr. Newberry held legal rights to the groundwater beneath his property? We were told that he claimed to have such rights. Did you research those rights before you paved over his well? The board consulted with our attorney. Did your attorney tell you to go ahead and pave over the well? Brenda glanced at Gregory Allen. We were advised that the HOA's authority superseded any alleged water rights. Alleged, Miss Hutchins, the water rights certificate is recorded with Maricopa County. It's a legal document. It's not alleged, it's real. Did you bother to verify that before you destroyed Mr. Newberry's access to his water? We relied on our attorney's advice. So you didn't do your own research. I'm not a lawyer, but you're the HOA president. You made the decision to authorize this work. Didn't you think it was important to understand the legal implications? I trusted our attorney. Richard let that answer hang in the air for a moment. Miss Hutchins, how long have you been HOA president? 5 years. And in those 5 years, how many lawsuits has the HOA been involved in? I'm not sure. Richard pulled out another document. According to court records, the Desert Highlands HOA has been sued 8 times in the past 5 years. All 8 cases involved homeowner disputes over fines or property violations. That's quite a track record, isn't it? Gregory Allen stood. Objection, relevance. Your Honor, it goes to the HOA's pattern of behavior and Miss Hutchins' leadership. I'll allow it, Miss Hutchins, please answer the question. Brenda's face was red now. The HOA has to enforce its rules. Sometimes homeowners don't like that and they sue. It doesn't mean we did anything wrong. In how many of those 8 cases did the HOA win? Silence. Let me answer for you. The HOA lost or settled 6 of those 8 cases. Doesn't that suggest a pattern of overreach? We have a duty to protect property values, even if it means violating people's legal rights. We don't violate anyone's rights. Yet here we are in court because you paved over my client's water source without permission and then retaliated against him with thousands of dollars in bogus fines. That sounds like a violation of rights to me. Objection. Argumentative, Gregory Allen said. Sustained. Move on, Mr. Martinez. Richard asked a few more questions, establishing that Brenda had personally directed the increased scrutiny of my property and had been aware of every violation notice issued. By the time he was done, Brenda looked shaken and angry. She stepped down from the witness stand and returned to her seat, glaring at me the entire way. The HOA called a few more witnesses, including another board member and a property management consultant, who testified about HOA authority and community standards. Richard cross-examined each one effectively, highlighting inconsistencies and gaps in their arguments. By 4 p.m., both sides had rested. Judge Morrison called for closing arguments. Gregory Allen went first, arguing that the HOA had acted within its authority, that the water rights certificate was outdated and superseded by modern water regulations, and that the violation notices were legitimate enforcement actions. Richard's closing was powerful. He summarized the evidence, pointed out the holes in the HOA's case, and emphasized that this was fundamentally about property rights. Your Honor, this case is about whether an HOA can destroy someone's property without notice and then punish them for objecting. The answer under Arizona law is clearly no. My client has legal, documented water rights that date back over 60 years. The HOA ignored those rights, destroyed his access to his own water, and then engaged in a campaign of harassment when he dared to fight back. We're asking this court to protect his property rights, compensate him for his losses, and send a message that HOAs cannot act as dictators over the homeowners they're supposed to serve. Judge Morrison looked tired as she closed her notebook. Thank you both. This has been a thorough presentation. I'm going to take this case under advisement. I'll issue a written ruling within 30 days. Court is adjourned. The waiting was agonizing. 30 days felt like 30 years. I tried to focus on work, but my mind kept wandering back to the case. Richard assured me that we had presented a strong case, but there were no guarantees. Meanwhile, life in Desert Highlands became increasingly uncomfortable. Brenda made sure everyone knew I was the guy suing the HOA. Some neighbors avoided me. Others were supportive but quiet about it, afraid of becoming Brenda's next target. Frank remained my most vocal ally, telling anyone who would listen that the HOA had overstepped. 27 days after the hearing, I got a call from Richard. The judge issued her ruling. We won. I nearly dropped the phone. We won. Complete victory. Judge Morrison ruled that your water rights are valid and enforceable, that the HOA had no authority to close your well, and that their actions constituted trespass and conversion of property. She's ordering them to restore the well at their expense, pay you compensation for all water bills since they forced you onto city water, and pay punitive damages of $50,000 for the harassment and retaliation. $50,000. The judge was not happy with the HOA's conduct. Her ruling is scathing. She found that Brenda Hutchins personally directed a campaign of harassment against you, and that the violation notices were retaliatory and baseless. She's also ordering the HOA to pay your attorney's fees. I sat down, overwhelmed. What happens now? The HOA has 30 days to comply with the judgment. If they don't, we can start enforcement proceedings. But Carter, there's more. The judge included a paragraph in her ruling suggesting that the county attorney should review whether the HOA's actions constitute criminal trespass or vandalism. She's essentially inviting a criminal investigation. That got my attention. You think they'll investigate? Given the judge's strong language, I wouldn't be surprised. What the HOA did was pretty egregious. The ruling became public record immediately, and word spread through desert highlands like wildfire. I started getting calls and messages from neighbors, some apologizing for not supporting me earlier, others asking if I could help them fight their own battles with the HOA. The HOA board held an emergency meeting 3 days after the ruling. According to the minutes, which were eventually made public, it was a disaster. Several board members wanted to comply with the judgment immediately. Brenda wanted to appeal. There was a heated argument, and in the end, 3 board members resigned on the spot, leaving the board without a quorum. Without a functioning board, the HOA was in chaos. They couldn't make decisions, couldn't enforce rules, and couldn't appeal the judgment. Brenda tried to hold onto power, but homeowners started circulating a petition to remove her as president and dissolve the entire board. 2 weeks after the ruling, I got a visit from a detective with the Maricopa County Sheriff's Office. Detective Sarah Ramirez was a no-nonsense woman in her 40s who introduced herself and asked if she could ask me some questions about the HOA situation. "Judge Morrison's ruling came to our attention," she said. "We're looking into whether any criminal laws were violated." I told her everything, from the day I came home to find my well paved over to the harassment and threats from Brenda. Detective Ramirez took detailed notes and asked for copies of all my documentation. "What you're describing could potentially be criminal trespass, vandalism, and possibly theft of services, since you were forced to pay for city water," she said. "We're going to investigate the HOA's actions and determine whether charges are appropriate. Will I need to testify? Possibly, if we move forward with charges, but that's down the road. For now, we're just gathering information." The investigation moved slowly but steadily. Detectives interviewed board members, reviewed HOA records, and talked to the construction company that had done the work. It turned out that the construction company had been told by Brenda that I had signed off on the work. They had never been shown any authorization, just told to proceed. They had invoiced the HOA for the work, and the HOA had paid them out of community funds. 3 months after Judge Morrison's ruling, the Maricopa County Attorney's Office announced charges against Brenda Hutchins. She was charged with criminal trespass, criminal damage, and fraud. The charges carried potential jail time. The arrest made local news. I watched on television as Brenda was led out of her house in handcuffs, her face shocked and angry. The news reporter described her as a HOA president accused of destroying a homeowner's property in a dispute over water rights. The case against Brenda went to trial 6 months later. I testified about what had happened, as did several other witnesses. The prosecution presented evidence of Brenda's emails and text messages directing the construction work, her knowledge that I hadn't been properly notified, and her subsequent retaliation when I objected. The defense argued that Brenda had been acting in her capacity as HOA president and had relied on bad legal advice, but the jury didn't buy it. After 3 days of deliberation, they found her guilty on all counts. The sentencing hearing was emotional. Brenda tearfully apologized, saying she had only been trying to do what was best for the community. Judge Morrison, the same judge who had ruled on my civil case, wasn't sympathetic. "Miss Hutchins, you abused your position of trust and authority. You destroyed Mr. Newberry's property without authorization, and when he objected, you attempted to bury him in bogus fines and violations. This was a clear abuse of power. The court sentences you to 1 year in county jail, suspended with 3 years of probation. You're also ordered to pay restitution to Mr. Newberry in the amount of $30,000, and you're permanently barred from serving in any HOA leadership position." Brenda's legal troubles weren't over. Several other homeowners who had been fined or sanctioned by the HOA during her tenure came forward with their own complaints. A class action lawsuit was filed, alleging a pattern of abuse and harassment. The HOA's insurance company eventually settled for a substantial sum. The Desert Highlands HOA board was completely restructured. New elections were held, and a slate of reform-minded candidates won. The new board's first act was to apologize to me publicly and begin restoration of my well. The restoration took 6 weeks. A specialized crew carefully removed the concrete pad, exposing the well cap beneath. My grandfather's carved initials were still visible, though scratched and damaged. The well itself was intact. They cleaned it out, tested the water, and installed a new pump system. When it was done, I had full access to my water rights again, just as my grandfather had intended. I disconnected from city water immediately. The difference in my monthly bills was stark. I went from paying $120 a month for city water to essentially nothing for well water, just the minimal cost of electricity to run the pump. But the victory was about more than money. It was about principle. It was about protecting my grandfather's legacy and standing up to bullies who thought they could do whatever they wanted, because they had a little bit of power. Frank came over the day the well restoration was completed. We stood in my front yard, looking at the new well cap that had been installed, a modern version that still incorporated my grandfather's original carved stone as a decorative element. "Your grandfather would be proud," Frank said. "He never backed down from a fight either. I just wish he was here to see it. I think he sees it, and I think he's smiling." The story didn't end there, though. Remember how the water rights certificate covered the original 5-acre parcel, which had been subdivided into multiple lots. That meant I technically owned rights to groundwater beneath about 40 homes in my section of the development. Several neighbors approached me about sharing well access. They were tired of high city water bills and saw my well as a potential solution. After consulting with Richard and a water engineer, we worked out an agreement. I granted easements to a dozen neighboring properties, allowing them to tap into the aquifer through my well. In exchange, they paid me a reasonable fee that covered the cost of maintaining the well and pump system. It was a win-win. They got cheaper, better quality water. I got help with maintenance costs and a small income stream, and the whole arrangement was perfectly legal because I owned the water rights. The new HOA board was supportive. They recognized that the well system was actually beneficial to the community, providing an alternative water source and reducing everyone's costs. They amended the community guidelines to explicitly protect grandfathered water rights and wells, ensuring that what happened to me could never happen to anyone else. Life in Desert Highlands gradually returned to normal. Brenda Hutchins moved away after completing her probation, and I never saw her again. The HOA functioned much better under new leadership, focusing on actual community improvements instead of petty enforcement actions. I stayed in my grandfather's house, the house he built with his own hands on land he had loved. Every time I turned on a faucet and tasted the clean, cold well water, I thought of him. He had secured those water rights back in 1963 because he understood how precious water was in the Arizona desert. He had built that well to last, constructing it with care and skill, and he had passed it all down to me, trusting that I would protect it. I had nearly lost it to an overzealous HOA president drunk on power. But in the end, the law had protected what was rightfully mine. Property rights meant something. Water rights meant something. And standing up to bullies, even when it was hard and expensive and stressful, meant something too. The whole experience taught me valuable lessons about knowing your rights, documenting everything, and not being afraid to fight back when someone tries to push you around. It also taught me that sometimes the legal system works exactly the way it's supposed to, protecting individuals against overreach by those in power. My neighbors learned something too. In the next HOA election, voter turnout was over 80%. People paid attention to who was running and what they stood for. The new board members were held accountable, and homeowners were no longer afraid to speak up when they disagreed with board decisions. The Desert Highlands community became stronger and more democratic. And in a strange way, my fight with Brenda and the old board had made that possible. By standing up and refusing to be bullied, I had shown other homeowners that they had power too. Years later, I still live in that house. I've made improvements and updates, but I've kept the core of what my grandfather built. The well still produces 50 gallons per minute of crystal clear water. The neighbors I share it with are grateful for the access and the lower bills. And every time I drive up to my house and see that well cap with my grandfather's initials, I smile. The HOA had tried to pave over my well and force me onto city water. They hadn't known that I owned the water rights, rights that dated back over 60 years and couldn't be taken away by any HOA rule or community guideline. They had made the mistake of thinking they had all the power. But in the end, the law was on my side, and they had learned an expensive lesson about respecting property rights and treating homeowners with basic decency. The $50,000 in punitive damages I received went toward further improvements to the well system and legal fees. The restitution from Brenda helped too, but the real victory wasn't financial. It was knowing that I had protected my grandfather's legacy, stood up for what was right, and won. Frank often joked that I should run for HOA president myself, but I had no interest in that kind of power or responsibility. I was happy just being a homeowner, living in my house, drinking my well water, and enjoying the quiet satisfaction of knowing that sometimes the little guy wins against the bureaucrats and bullies. The well continued to function perfectly, providing water for me and my neighbors. The aquifer my grandfather had tapped into showed no signs of depletion. The water quality remained excellent, better than city water by every measure. I sometimes gave tours of the well system to curious neighbors or visitors. I explained how my grandfather had drilled it, how the water rights worked, and what had happened when the HOA tried to take it away. People were always fascinated by the story, and many of them said it inspired them to research their own property rights and stand up to overreach in their own HOA situations. The legal precedent set by my case also had broader implications. Other homeowners in Arizona who were fighting their HOAs over water rights or other property issues cited Judge Morrison's ruling in their cases. The decision became a touchstone for property rights advocates, a clear example of courts protecting individual homeowners against HOA overreach. As for me, I continued working at the insurance firm, living my life and enjoying the house my grandfather built. I dated, had friends over for barbecues, and gradually built a full life in Desert Highlands. The neighborhood, freed from Brenda's tyrannical leadership, became a genuinely pleasant place to live. The well remained the heart of my property, just as my grandfather had intended. It provided water, represented my family's history, and stood as a symbol of the importance of knowing and defending your rights. In the end, the HOA had paved over my well and tried to force me onto city water. But they hadn't counted on me owning the water rights, rights that were older than the HOA itself and protected by law. Their mistake had cost them dearly in money, in reputation, and in the case of Brenda Hutchins, in criminal consequences. And me. I had my well back, my rights intact, and the satisfaction of knowing I had stood my ground and won. My grandfather would have been proud. The well he had dug with his own hands in 1963 still flowed strong, providing clean water and representing everything he had worked for: independence, self-reliance, and the courage to stand up for what was yours. That's how a simple dispute over a well became a major legal battle, a criminal case, and ultimately a victory for property rights and individual homeowners over an out-of-control HOA. And that's why, to this day, I drink my well water with pride, knowing exactly what it cost to protect it and exactly why it was worth every penny, every sleepless night, and every moment of stress. The water from my grandfather's well tastes sweeter than any city water ever could, not just because of its quality, but because of what it represents: freedom, justice, and the enduring power of standing up for what's right.